Welcome in, everyone. It is Thursday, July 22nd. I am your host, Mark Reel, and tonight we have very special guests. We're going to change it up a little bit. We have Arkansas Attorney Brian Vandiver. So welcome, Brian. Thank you for coming in. Brian is not a practicing family law attorney, but as a lot of you know, a lot of the conversation, the state of Arkansas this year became the second state in the United States to pass a 50-50 presumption in their family law courts. And we were just talking here in a few days, that law is actually going to go into effect. So tonight, the next hour, we are going to spend talking about the work Brian did and the work the rest of the crew in Arkansas did to get that across the finish line. So welcome in, Brian. Thank you for joining us tonight. So we'll dive right in and tell us I know we talked before we went on here. Tell us a little bit about the history of the parenting laws in Arkansas up until this change in 2021.
Sure. Thanks for the invitation. I'm honored to be a guest. So in Arkansas, we've had an evolution in the change of the law. Before 2003, like many other states, joint custody was disfavored, not even allowed as an option. And then we had a tweak in the statute that allowed the courts to do it, but it was still disfavored. And then in 2013, we had a really good law passed, sponsored by my good friend Mark Lowry, my representative, that said joint custody is going to be favored in Arkansas and actually defined joint custody as a reasonable and approximate equal division of time between the parents. And, we thought that was a win and that was a good step. Unfortunately, the courts continued to interpret that law and found ways to not award joint custody, whether the parents couldn't get along or fighting, what have you, and the outcomes just didn't match up with the intended result. So we came back in 2019 with a rebuttable presumption bill that failed in the Judiciary Committee. And after that failure, we got our team together. I've been aligned with Arkansas Advocates for Parental Equality. Patrick Fraley started that organization in 2015, I believe, and his wife, Gina. They've been instrumental in this grassroots effort in Arkansas. And Patrick's really been the architect of the whole thing. Gina has been the volunteer lobbyist. It's been day-to-day, boots on the ground, making contact with various people. And so we kind of formed our plan of what we wanted the bill to say and what we needed to do to get it passed. And that's kind of where it started. And we got it across the finish line this year.
Awesome. And yeah, that's a huge deal. I tell people now, Arkansas, as of a few days from now, is going to have the strongest equal and shared parenting law in the country. Huge step forward, taking even a half step forward from what Kentucky has. So let's go back to the beginnings, the startings of, you said in 2019, it had a rebuttable presumption bill that failed. And then you set out kind of a 2-year plan as to what you needed to do to get something through. So for our viewers, talk about where that starts. Is it drafting the bill? Is it getting legislators involved? What are the first couple of steps that someone would need to do or that you guys found success with in the state of Arkansas?
Well, I think one is writing a good bill. And we had a lot of people that supported us throughout this process. Kenneth Rosa at Fathers' Rights Movement, Mark Ludwig at AESP, Don Hubin at National Parents Organization. We're not affiliated with any national organization, but we are aligned with all of these national movements because we all share the same goal of equal shared parenting. And so we had a lot of input from different people. We looked at the Kentucky statute, took the best parts of it, but then we said, we want the Holy Grail. We want the clear and convincing rebuttable presumption. And we wrote it in a way to achieve that, because once you change the burden of proof, a lot of other dominoes fall. And that was kind of our goal in writing a good bill and then finding good sponsors and co-sponsors who will go to bat for you in the legislature. Senator Alan Clark, who's been a champion of children's rights in our state, and Jimmy Gazaway, who is the representative sponsor, is an attorney and did an amazing job presenting the bill in committee and advocating for us. So we had some really strong sponsors. We had a broad spectrum of co-sponsors, men, women, Republicans, Democrats, and then we had a lot of support from various communities, whether you have conservative family rights groups or more liberal minority fatherless groups that are focused on how can we get more men involved in children's lives. And we had a broad spectrum of support. And I think we really surprised a lot of people in the group we put together.
Yeah, I think that's a big point, and I've had the opportunity to speak with and talk with a lot of the individuals that you mentioned there, and I think one of the biggest takeaways I've had is Don Heuben has obviously been in the game and has been around the movement for decades now, and his biggest piece of advice to me around any of it was if any group, if any person, even if the bill is imperfect, gets any momentum, everyone needs to throw all of their weight behind it. It may not be perfect. It may not be exactly what you want. It may not be achieving exactly what you set out, but any chance to get a proverbial first down when it comes to improving the laws, everyone needs to band together in that sense.
That's right. So, we're all on the same team in the end.
Yeah, and definitely. And then you mentioned in terms of the support of the general public, going out and getting different groups. They may have different views of what these laws should be or what they're going to achieve. But at the end of the day, we've seen it in multiple states now. There are Democrats, there are Republicans, there are conservatives, there are liberals, there are every segment of the population. If you explain it to them and you explain what the benefits of it are, it's probably one of their core tenets that they want to pursue. So,
absolutely.
Yeah. So let's go. So you mentioned drafting a good bill. That's the first piece of it, and that's the biggest thing. So in terms of you obviously the original bill you drafted isn't what became law. That's just kind of the process, and we'll dive into the legislative process a little bit later. What would you say for someone who's kind of seen the process over a 2-year period culminate in success? What are the keys to drafting that bill?
Well, we hope that our bill is a template or a springboard for a lot of other states that they can use our bill as a source of inspiration. I think the key for us was knowing what our code said already and knowing how to tweak it in a way that really maximize the impact for custody litigation. And, you can have non-lawyers involved, but it really helps to have lawyers involved who know how to write code and know how to draft a bill and help the legislators understand what the language in the bill is going to do. And so when you have attorneys who are also legislators that can help amend the bill, write the bill, and know what the language is going to do, that is a huge asset. And so we knew we wanted the clear and convincing standard. We knew we wanted to add language in there to address what's the so-called conflict exceptions, so that we've had a lot of courts in Arkansas say that when there's conflict and parents can't get along, well, you can't award joint custody, and that's just not true. And so we had language specifically geared towards that to say, no, judges, you need to try to address conflict in the order and preserve joint custody. And then language that says even if there's not going to be joint custody, we're still going to maximize the time with the non-custodial parent. And judge, you're going to have to make specific findings, facts, and conclusions of law. And as a lawyer, that means that's one, more work for the judge, but two, you're creating a record. So the judge is going to have to justify his or her decision of why they are deviating from joint custody.
Yeah, and I think I always point to there are three major components of there's obviously a lot that goes into a good custody law, but there are three major components: that 50-50 rebuttable presumption, the standard that must be met to rebut that presumption, And then if that presumption's rebutted, you get facts, findings, and conclusions of law, because like you said, that's more work for the judge. So if the judge goes against that, they have to go back chambers and they have to actually put on paper why they did what they did. And number two, it creates that paper trail. Family law cases essentially are, unless there was some egregious decision, were very low success rate on appeal. But now the judge has to go back if they deviate from that presumption and list out exactly why they did what they did.
That's right.
That in terms of as me as a family law attorney, that's a huge piece. And we've seen, I think it was 5 states this year ended up getting facts, findings, and conclusions into law. I think 4 of those states were very disappointed at what they ended up actually getting through this year. But that's a big win, because it does create that accountability. That's what I think it creates accountability with the judges.
It does. It does. It creates accountability and makes them justify their decision. And, I think we kind of hit the trifecta with our bill and now our act, and we're very proud of it. But I think, going back to where I started, you need to know what your code says currently to know how to fix it. And every state's different in how their code is written on family law and child custody.
Yeah, and I think the big piece is I found too is that different states, different views, obviously different political leanings. You're going to need to be able to go in and pitch things differently. Arkansas, very conservative state. You're going to be very red. It's going to be more of the conservative values that are going to get pitched to the senators, to the representatives. And if you're in a liberal state, it maybe have to be one of those things where you're stronger on we're putting fathers back in homes, and the statistics around that fathers of color are 3 times more likely to be pulled out of their children's lives. So the big piece in that is you're going to have to educate yourself.
And we made a specific effort to not only educate ourselves, but to educate the legislators. And what we did, and I think whether your state is red or blue, statistics don't have a political leaning. And so what we did is we put together binders of statistics, research from Fabricus and other therapists and scientists and researchers that have weighed in on this and been published. And there's just stacks and stacks of literature on this. We bound it and put it together and gave the committee members hard copies of that. So they had the research, they had the statistics, and we educated them to a large degree on facts that are indisputable, and you can't argue with them. And so when someone comes in to argue against the concept of joint custody, they have to argue something other than statistics.
Yeah, 100%. And then, it goes back to the fantastic work that NPO does in terms of, I think they have about half the states in the country at this point where they've went out and they've polled voters. And that's something it's, I think, 3 pages. You can go slap on a legislator's desk and say, this is something that has, in the terms of in political terms, something having 80 to 90% of the general public support is insane. That doesn't happen. And that's what the NPO polling shows.
We had that specifically for Arkansas. Don Hubin and NPO did that for us. We had, I think, 90% support of the concepts in our bill of joint, shared, equal parenting. And once you present that to legislators, it's hard for them to vote against that.